And may I think now request Shankar, can you join us? Shankar is a founder and CEO of Viteos Fund Services, and recently he was involved in major sale of his company to Wipro. I think that's the latest. I think we had an opportunity to work with him, so it would be very nice to see his perspective. I worked with him for a long time now on other IPOs and other matters in the past. It's been wonderful, dealing with him, very professional. And Ankit is a senior member of our M&A practice group, and he's based out of Mumbai. So Ankit, welcome. So, okay. So let's, I think, quickly get into the discussion straight away. Simon, addressing regulatory risk is one of the most important considerations for a successful M&A deal in India. How have you managed this risk for your clients, if you can?
Sure. So let me just, sort of step back and define what this regulatory risk really is. I think let's talk about the regulators. We have about 5 regulators that one would deal with in a typical M&A deal, or at least one of the 5. One is the foreign exchange regulators, which is the RBI and the FIPB. The Foreign Investment Promotion Board is basically the overseeing authority for any sort of investments coming into India. We have 2 different sectors. One is the automatic route and one is the government approval route. So companies that engage in activities that require approval, for instance, like the pharmaceutical sector. Any brownfield pharmaceutical sector requires, you need to seek the approval of the FIPB to actually have foreign investment into it. So the FIPB and the Reserve Bank of India is also a regulatory authority that actually makes laws that govern our foreign exchange. So that's one. The second is the Securities and Exchange Board of India. This is if and only if you're doing a listed transaction. That means you're acquiring a company that is listed on Indian bourses. Then you would deal with the Securities and Exchange Board of India. The third, I think the most talked about, the most famous authorities are the tax authorities that you would have to deal with, or you would have to consider when doing a deal in India. The fourth would be the Competition Commission of India today, who is the antitrust regulator in India, and any deal or any transaction of a sizable nature may need its approval to go ahead. I think these are the 4 sort of regulators 4 sets of regulators that you would deal with in a typical M&A deal. If you're doing a deal in the regulated sector, for instance, if you're doing a transaction in the insurance space or in the aviation space, for instance, you would have a different regulator to deal with, which is a sector-specific regulator. In case of a financial services deal, it's typically the Reserve Bank of India. The aviation has its own set of authorities as well. So it's a civil aviation ministry. So I think these are the actual regulators that work. People consider regulators, there's a lot of sort of regulatory risk. It's not really because of the regulators themselves, because the regulators are there to regulate sectors. Given India's economy, given the fact that it's growing, it requires certain protections in different areas. So it's not really a regulator, really a concern. But I think the concerns are twofold. One is the fact, I think we just witnessed it in the poem discussion, the fact that laws are not very well written in India. So therefore, interpreting them, is a quite an interesting task. And if you look at, we have sort of so many regulators, it's any wonder that even one regulator and the other would have the same view on a certain subject matter. So that's one risk, and I'll sort of give you an example of what really happened in a large M&A deal. So that's one. And second is the interface with the regulators. People are perceiving them to be more sort of hostile and very inquisitive and not very approachable. With respect to the second aspect, that is far changing today. This government today is very pro-investor and very pro, ensuring that the regulator sort of treats the investor as a customer as opposed to a burden or liability. So with respect to number two, I think regulators today are becoming more approachable. They are, responding to queries asked, and I think the interface is a far more pleasant one. It's also moving more electronically as opposed to actually making physical contact with regulators. So that's one step in the right direction. The biggest problem that India faces today is the fact that our laws are not worded well. It's scope to multiple interpretations, and there's a lot of delegated legislation which brings about changes in laws on a very rapid basis. I think Daniel was sort of alluding to you having the right people and looking at things in a current form, and he couldn't have been more right, because on an everyday basis or every minute basis there could be something different, whether it's a court decision that changes the interpretation of things or a subsequent circular which sort of reverses an earlier position. Interestingly, when Etihad, the Middle Eastern airline, was trying to acquire a jet, the question that arose was, really speaking, how were they sort of acquiring jet, and were they really acquiring control? The FDI policy had just been opened up to allow strategic airlines to participate in the Indian aviation sector. But the main condition was that you can acquire up to 49% without acquiring control. Now, Jet was a listed company. So you would have an interface with the Securities and Exchange Board of India, which also says that if you acquire today 25% and above, you need to make an open offer, or if you acquire control, you need to make an open offer. Now, the 25% trigger is important because you can, once you have 25%, you have to acquire today, a 26% from the public shareholder. So, the worst case scenario would be that you would acquire 51%. Since you can't really acquire control, you couldn't really do anything more than 25% in a listed company. So, therefore, the deal was structured such that Etihad would acquire 24% in the company. Alongside that 24%, there were usual rights like affirmative votes. The Etihad had the right to sort of appoint certain CEOs, certain management in the company. The question that arose was, was this really control for the purposes of the various laws? One is the SEBI law, the FDI policy, and then the Competition Commission of India. Now, again, our antitrust regulator, says that if you acquire control of a company, you need to make and you meet certain financial thresholds, you need to have a pre-merger clearance from the regulator. Now, interestingly, the definition of control is, the same, or more or less the same across all legislations, whether it's the FDI policy, whether it's the Takeover Code, which governs listed companies, or the Competition Act, which governs antitrust filing. So the definition is the same, and one would think that when the definition is the same, one regulator could take the same view as the other. The FIPB said, fine, this is okay, we surpassed this, there should be no concern, you have affirmative rights, they look like they're sort of passive rights, they're okay, the investor protection rights. The Securities and Exchange Board of India took a little more time to sort of evaluate the entire proposal and said, okay, fine, they were okay with it, saying this deal seemed fine, didn't look like Etihad was actually acquiring control. But they had one caveat in that go ahead. They said, look, if any other regulator takes a different view, we will sort of recall, we have a right to look back. And lo and behold, when the transaction went to the Competition Commission of India, the commission said, look, the transaction is fine, we give you our approval to do it, but you are acquiring control, and therefore, even though it's fine, you are acquiring control. So, this entire decision went back to if one regulator says, yes, this is controlled, does the SEBI today, should it take a different view? Should the FDI policy, the FIPB sort of block this transaction, and it became a complete turmoil. A transaction which was supposed to, complete in 3 to 4 months took a whole lot of time because of this entire concern. But the end result is good news. The regulators took a very proactive stance, saying, look, even though the definitions may be different, and this is what everyone sort of fears, different laws can allocate to different contexts, and therefore regulators can take, a definition, even though the same, can apply, can mean different things in different contexts. So in the context of the Securities Exchange Board of India, this would not amount to control. In the context of the FDI policy, this would not amount to control, even though the antitrust regulator looked at things differently. So I think in terms of advice to acquirers here, one is, yes, we have very stringent regulations, but with persistence and a little bit clarity of thought, you can sort of throw reason and achieve your end objective if that is what you need.
Yeah, but I think let's talk about competition law. But Ankit, can you just very quickly talk about, what are the specific antitrust and considerations that parties should take into account? If you could be slightly quicker, that would be very nice. Thank you.
Very quickly on a lighter vein, you have heard since morning what you can do, what you cannot do. I have to sadly give you the unpopular message of what you cannot do, and that's really what antitrust law really is. Now, very quickly, conceptually, essentially, if you meet certain asset and turnover thresholds in India or worldwide with a de minimis in India, you would require a filing with the Competition Commission of India, which was established, and the entire merger control regime came into force in 2012. So essentially, if you meet certain asset turnover criteria, then you will have to make a mandatory filing, which is very similar to what you have in the US. Unfortunately, the only difference in India as opposed to what you have in the US is that in the US there is another criteria, which is the size of the transaction criteria. You don't have a size of the transaction criteria in India. So even if it's a $1 transaction, if you meet the asset and turnover thresholds, you will have to make a mandatory filing. Now, what happens when you make a mandatory filing? Essentially, you have a very similar concept than what is there in the US with a few differences. You have the phase 1 investigations. Almost 300 cases have been filed before the antitrust authorities, and only 2 cases have gone for a phase 2 investigations. In the phase 1 investigation, it's a 30-day timeline. So typically you make a filing on the day you execute a document, and within 30 to 45 days the commission gets back with whether it's approving the transaction or it's going to go for a phase 2 investigation. If it goes to a phase 2 investigations, then the waiting period is around 210 days. Unlike the US, where you can ask for an early termination of the waiting period, you cannot ask for an early termination of the waiting period in the Indian antitrust context. So therefore, once you make the filing, you will have to wait for the commission to get back to you whether the transaction is approved or not. A few things to be sort of kept in mind. In the last couple of years, what we have seen, that there is an urgency to sort of define the relevant market narrowly while undertaking a sort of analysis. So the Competition Commission of India has defined relevant market in a particular way narrowly, and also one of the complexities with respect to India is, which I think Daniel pointed out, is that India has almost 29 states and 7 union territories. So even the geographic market is not the whole of India at times, it's regional based. So that's something that you'll have to factor in. Now, what does all this sort of mean while you're doing a transaction very quickly? Is that the moment you have to first, while stepping into a transaction, very quickly analyze whether the transaction requires antitrust filing in India or not. The moment you determine whether the transaction requires antitrust filing, from that point onwards, till the closing, you need to be absolutely sure that you're in compliance with antitrust regulations. Now, what does that mean? That, for example, if you're conducting a due diligence, you need to be very careful to ensure that you don't get sensitive information from your competitor. For example, certain information relating to customers or suppliers which could have certain antitrust concerns. Similarly, you should not consummate any part of the transaction before getting the approval of the antitrust authorities. And also, in terms of the document you present before the board for analyzing the transaction, you need to ensure that you don't use terms like we will we will kill competition in a certain sector, because then you're really playing into the hands of the regulator. So none of these issues are unsurmountable, but what you need to keep in mind is that it requires sort of delicate handling and sort of careful examination once the determination is made that the antitrust filing is required. And once that is done, I think you will be able to navigate through some of these antitrust concerns in India.
Just to add to what Ankit said, I think it's important to understand that the Indian competition law also has extraterritorial impact. So in one of the recent deals which we were doing where India was indirectly involved, so there was a US company it was a distressed deal for $1. A US company was acquiring another US company from a US seller. So the target company had an Indian subsidiary. And the way this entire transaction was structured was through a reverse triangular merger in the US. And as you know, most of you must be knowing, in US the reverse triangular mergers are tax neutral. And that's why instead of share acquisition, it was structured as a reverse triangular merger. The problem with the reverse triangular merger in India is there are certain exemptions which are given for not filing the notification with the Competition Commission of India. Those exemptions apply to a share acquisition and asset acquisition, but they don't apply to merger. So if you structure your overseas acquisition as a reverse triangular merger, you could be triggering competition law filings in India. So that's something you should just keep in mind when you are, when an Indian piece is involved in an overseas acquisition, and what structure you are using could have an impact on India.
Interesting. But Shankar, I think everybody's waiting to listen to you. You just did a deal with Wipro. And what has been your overall experience in the deal, and how did you?
Sure. I mean, as you mentioned, and many of you are aware, in some ways, I feel it's still hot off the press, as in we're in the period between having announced definitive agreement to sell our company to Wipro on an all-cash basis of 130 million, and hopefully some of my colleagues here are still responding to emails to ensure closing happens next Friday. But I think we're on track to get there, and we have everything under control. But frankly, the whole experience of going through the process of exiting, creating an exit for some shareholders, majority of the shareholders in the company, through a sale of the company was a simple process, but yet extremely complex. I mean, when I hear of all the different regulatory bodies that Simon just mentioned, I'm just thankful that we didn't have to deal with any of those, but we had our own complications of a Mauritius holding company with subsidiaries in India, US and Cayman, and Wipro, which is an Indian company, but with presence in different parts of the world. What we did was we did a sale of each of the subsidiaries of our holding company to meet different stakeholders' needs. So we had the complexity of making sure that while the shareholders, who were all global shareholders of a Mauritius company, whose interests had to be protected from a tax perspective. I think the earlier panel talked a lot about the India-Mauritius Treaty and the ability to construct transactions where shareholders are not taxed for a transaction of this sort. You also had to keep in mind that we had employees of all three companies who were option holders, and how we structured their buyout, who are going to continue to remain employees of the ongoing entity. And I think what was front and central in all of that, which is not really surprising to all of you over here, is in many ways the theme of today's whole conference that Nishith and his team have put together, which is companies from India are as sophisticated or as capable as anywhere in the world today. I mean, we went through an auction process for almost 4 months and had multiple bidders, and because of the nature of the business we were in, we had interest from outsourcers to banks to IT companies to PE firms, and each had their own dynamics of how they wanted to execute the transaction. And it was an interesting opportunity for us, and thanks to everybody on this table, as well as Nishith's team back in India, who participated in the process almost for about 8-9 months, even before we appointed a banker, in helping us to think through these things, and because of which, when we had multiple parties negotiating purchase agreements at the same time, literally in different rooms simultaneously, we were able to forcefully come out with a structure that met all the different stakeholders' goals of ensuring that there was protection from a tax perspective, there was protection for employees from their gains, as well as ensuring ongoing continued employment, while keeping in mind that the buyer had their own limitations of how they could execute such a transaction. And all this you had to do while you have to manage market dynamics of customers and employees, and as a small company, word getting out of the transaction could be detrimental to our business from a client perspective. So simple transaction, small in size in compared to some of the other deals listed on the sheet, but nevertheless posed its own interesting moments. And all I can say is that it didn't matter that there was Indian regulation and Indian company, that Wipro competed as well as any other company that was in the conversation to make this happen.
Weber, you've been involved in this transaction, many other ones. What's your experience? Which kind of terms that you think are most heavily negotiated, and what kind of practice has evolved over a period of time?
Yeah, thanks. While I was involved in this, I am not talking about this deal specifically. I'm talking my general experience. In India, almost everything is negotiated. That's how you need to mentally prepare yourself. I will talk about 5 points which are heavily negotiated. I will talk about what is the standard, or what is generally what you kind of end up with. I think the first point is the basis of valuation. What we are seeing in India is generally people will go for cash-free, debt-free kind of valuation. Then often they will ask for certain working capital requirement to be kept in from the cash perspective. So debt-free, cash-free basis with certain working capital is more or less standard. Generally we have seen maybe 3 months, 6 months working capital kind of a concept which people negotiate. As soon as that happens, the next question really is the pre-closing adjustment and the post-closing adjustment is often heavily negotiated. Especially, when you are doing an adjustment, what should be included, what should be excluded. Sometimes negotiation goes into a situation that, look, if tomorrow I get a tax refund, then, I need to get additional money, and that should be part of adjustment. Or if a certain thing happens, then that should not be a part of adjustment, kind of a concept which is always discussed. Also in India, we are seeing now more lockbox kind of a deal also happening. So that is something which is a new development in India. The second clause which has been heavily negotiated is always an ME clause, which is material adverse effect clause. Material adverse effect, as many of you know, allows a buyer to walk away from the deal if between signing and closing, if any thing happens which leads to a material adverse effect. And this specifically is very critical when you are doing a deal which requires some of the regulators' approval and which can be time consuming. Now, what we see here and what we have seen in last at least couple of years is that deal ME clause generally has been more seller friendly than buyer friendly, and that has been some of the kind of the way it has been. 2 things they always try to do. One, you will have a specific or you will have a general carve out of what is ME, which is, if something goes around the industry which causes materially, the business is not in the same way, there are certain maybe 25% less valuation, etc. It's more of a generic carve out. But in addition to that, there are always a specific clauses which they say it will become a material adverse effect. For example, if you lose certain customers, then it will become a material adverse effect kind of a thing. So always that negotiation becomes very, very critical. The third point of negotiation, as usual, will be reps and warranties. In India, just a couple of points, you will have a kitchen sink reps and warranties, put it in, but the negotiations will always happen on which reps and warranties should be qualified. with knowledge, which cannot be qualified with knowledge, and often we see that to be a major aspect of negotiation. Also with reps and warranties comes disclosure letter, and that is the other area where you see a lot of negotiations. The negotiation you will see is, whether the data room should be completely as a disclosure, as a exception to the reps and warranties, or should there be a specific disclosure against each reps and warranties. And this negotiation I have done in every transaction. It has happened. I have seen this happen. What ultimately happens is, in 95% of the cases, we have seen specific rep and warranty to come in, which means that data room disclosure is not yet a norm in India. Having said it, again, there's a discussion or a disclosure saying that, look, if the buyer knew about certain, defects or certain things, and whether it's not been disclosed, whether there can be a remedy against that or not. So that always is another issue which is discussed on specific indemnification and so forth. Then another point is disclosed is between signing and closing, whether the seller has a right to update the data room, the disclosure schedule, and if it's update the disclosure schedule, what is the implication? Whether buyer can walk away, whether it can have to compulsory give indemnification, whether it does not have to give indemnification. And generally this area, while it's negotiated, what we see is that the seller has a right to update disclosure schedule, and buyer will get indemnification, and if it causes mutual adverse effect, then buyer can walk away, but generally buyer cannot walk away as long as he gets the indemnification. So this is what generally we have seen. Then next is indemnity. What we see in indemnity, the first is always what is the maximum liability which a seller has. That's a question which is asked first. If you had asked this question to me 3 years ago, this norm at that point of time was 100% of the payment which buyer pays is used as a cap for limitation of liability or cap on the indemnity. Nowadays, what we are seeing is more something similar to what international market is. For title and fraud, it's still 100% of what purchaser has given the seller. However, for other reps, it is limited to anywhere between 10% to 35% of the transaction value. And this is what has become a norm even in India. Of course, the other point you will always discuss and negotiate is, are there any specific indemnities given? For example, if the litigation going on, or especially in India, what is hotly negotiated if there are tax litigation going on, then whether that should be part of a specific indemnity or not, and whether there can be any liability or not. And this is generally a hotly negotiated. There is no standard which I have come across. We have seen various solutions. In some situation, we have seen there is a cap up to which the tax indemnity is asked for given. In some situation, we have said that there is a deductible for a tax indemnity, which means that the buyer will pay certain amount, for any tax liability which comes, but over certain amount, then seller will, take care of it. So we have seen various kind of solutions which have been brought in on specific indemnity for tax. The other area of negotiation on indemnity is basically the period of how long the indemnity will survive. And while international standards are 18 to 24 months, in India, we still see 3 years as more common, though in recent deals we have seen more coming down to 18 to 24 months for general indemnity. For tax indemnity, again, it goes to 7 years after the assessment period is over, which means that that is becoming more in standard. And for title and fraud, there is no limitation which generally is applied. So this is what we are seeing from indemnity perspective. The other aspect which always come in is whether there should be de minimis. Generally, there is a de minimis, typically a small amount, depending on the deal size, but 10,000 to 25,000 is what I have seen on an individual de minimis. And then the question is whether there's a tipping basket. Now, what tipping basket typically means is that if there is any claim which is above the de minimis value, then that goes into a basket, and until the basket is completed, the buyer will not claim that particular amount. So that tipping basket is another area of discussion. What we have seen is generally about 1% of, or 0.8 to 1% of deal value, depending on the size of the deal, is what the tipping basket is. Sometimes seller asks for deductible, which means that when the basket is tipped, you can't sue for that particular amount. You can only sue above that particular amount. But that's something which is becoming rarer. I mean, I've not seen many buyers accept it. So it's typically a tipping basket concept which applies. The last point I want to mention in negotiation is earnout. Earnout, especially in technology industry, is very, very common and very highly negotiated, both commercially and legally. Now, what happens on earnout? First, as Nishil mentioned in the first panel, that there is no automatic approval for earnout if there is a foreign buyer who is buying shares of Indian company, and there are shareholders who are Indian shareholders, and specifically employees who are our management will be party to the earnout. So that becomes a question on how do you structure an earnout. However, recently what we have seen is that while it's not possible on automatic basis, if you go and approach Reserve Bank of India is giving permission for deferred consideration or earnout consideration, as long as the immediate money paid, which is the non-deferred component of the consideration, is above the fair market value. If it is above the fair market value, there are good chances you will get the approval. If you get the approval, you can do it in a classic earnout situation, which you do in the US, but if you don't, then you need to go into different structures. Now, having said it, one other issue which comes with earnout is on the tax side. Now, the moment you do a deferred consideration under Indian tax law, whether you get the deferred consideration or not, which means whether even if it is a contingent consideration, become your income at the time you sell your shares. And that becomes another issue which needs to be taken care of on how would you do it. So structuring of an earnout is another highly negotiated aspect because it is something which affects the management and the employees very heavily. I think with this I will pass to Nishith.
Yeah. No, I think I just want to turn back to Shankar a little bit, and how different are regulatory risk in your experience in India compared to what you've seen here? A quick word on that. Of course, we heard in the earlier panel as well.
Sure. I mean, as I mentioned earlier, as it related to this transaction that we just went through, we didn't have any regulatory requirements because we were under the size, or the transaction amounts was even at 130 million was lower than what might have required regulatory approvals. But I do want to say that you're aware that we worked together 15 years ago on doing another listing in NYSE listing, and then did subsequent acquisitions of a NASDAQ company in my previous life, and which your firm again helped us. I can only say that there's a world of difference between 2000 and 2015 in how you think about transactions from an India perspective. There were so many limitations at that time for us to even think about what we can get done today. From our own situation of regulatory, I think the only requirement we had was because we had a Cayman entity where we have a mutual fund administration license. We were under the regulators' guidelines to have their permission to sell the shares of the company, but otherwise we weren't really governed by any regulatory limitations to do the transaction.
Thank you. I think we'll have a couple of questions and then open up to question and answers from your side as well. But Nishil, very quickly, can you tell me the typical transaction tax issues and, what kind of documentation, or how important is it? If you can be a little quick, that would be
Sure.
fine.
So I think the biggest tax issue which is plaguing cross-border deals in India is the withholding tax issue. Now, the way the Indian tax laws are worded is if a seller sells the shares of an Indian company to a buyer, then it is the obligation of the buyer to pay tax to the Indian government and not the seller. So the reason why this becomes important is because ultimately the assets are going to be of the buyer, and it's easy for the tax authorities to attach the assets of the buyer as compared to the seller who has already exited the country. Now, the issue which comes up is most of the investments in India are done through tax tax-friendly jurisdictions like Mauritius, Singapore, and Netherlands. And these countries have excellent tax treaty with India, which exempt capital gains tax from India. So, these treaties take away the right of Indian government to tax capital gains when entities from these countries exit from India. The challenge comes up in a situation where the Indian tax authorities, in spite of the treaty clearly exempting such capital gains, starts looking at taxing these transactions. The buyer starts getting jittery. Now, the problem is because if the buyer does not get sufficient protection from the seller, then what happens is the tax authorities can claim this tax from the buyer, and the seller has already exited. So buyer has not only paid 100% of the purchase price, but on top of that he has to also bear the capital gains tax of the seller. So what we have seen is we actually, when we are negotiating deals, we almost spend 30 to 40% of time just negotiating tax indemnities. And this has become extremely important because especially in situations where the target companies are owned by private equity investors, the biggest challenge we face is typically a fund life is about 8 to 10 years, right? And the exits happen at the fag end of the fund life. So, when you are in the fund life is 7 or 8 years, the exits start happening. From an Indian tax perspective, the Indian tax authorities can chase the buyer for a period of 7 years from the date of the transaction. Now, the fund life is only 3 to 4 years as far as the seller private equity fund is concerned. So, how do you bridge the gap? Because if the tax authorities come between 4 to 8 years, 4 to 7 years, then the seller as a private equity fund has already wound up. So, there are no assets left. And from a buyer's perspective, he doesn't have anything, he had not deducted any tax at the time when the transaction took place. So this issue comes up, and we have seen various types of structures being devised to address this issue. One being, specific undertaking from the general partner that, he will exercise the clawback rights from the limited partners in case, such type of tax indemnities get triggered. Second, we have seen in extreme situations where buyer has a great negotiating power on the deal to hold back certain amount for a certain number of years, maybe 3 to 4 years, because that's the time by when typically you will get the notice in case the transaction is taxable. We also seen private letter rulings where you can approach the Indian tax department, for getting certainty on the tax, but that period which earlier used to take 6 months is now ranging from 18 to 24 months. So that also is not a good remedy. And the most important and the easiest solution which both the buyers and the sellers had found a few years back was tax insurance. So you go to an insurance company, get an insurance for insuring your tax amount. You pay a premium of 5 to 7% of the tax cover you are taking, and both the buyer and the seller can sleep peacefully, and the headache is transferred to the insurance company. A lot of these tax insurances happened, a couple of years back, but unfortunately the risk appetite of the insurance companies has also reduced over a period of time because they also cannot predict what the Indian tax authorities will do. So even insurance companies are afraid of insuring the tax risk in India, and that's one of the major issues which both the buyer and the sellers are facing. The other big issue which we have seen is, as I mentioned, Indian tax laws are extraterritorial. So if you are doing a US transaction where, again giving the same example, a US buyer, US target company, US seller, you will feel that there is absolutely no issue, everything is happening in US, we don't need to worry about India. That's not correct. If your US target company has an Indian subsidiary, and that Indian subsidiary forms more than 50% of value of the US target company, then that transaction is taxable in India if there are capital gains which are earned by the seller of the US company. And this always comes as a shock to all the US law firms, US clients we work with, Because if you see the reverse, when an Indian shareholder sells shares of a US company, US doesn't tax non-resident on capital gains. Here we are going one step ahead. We are not only taxing direct transfers, we are even taxing indirect transfers. So even if you do the transaction 3, 4, 5, 6 layers above, if ultimately the value of your US target company is derived from India to the extent of more than 50%, then there is not only capital gains tax implication, but the buyer is responsible to pay that capital gains tax to the Indian tax department. And that's why all the foreign acquisitions have become very tricky. The way the law is drafted is also not very clear whether you take cost of acquisition of shares in the US company or you take cost of acquisition of shares of the US company in the Indian company. And if there are multiple layers, where do you stop? So it's a very complicated law which the government has introduced, and interestingly the law was introduced in 2012. And this law dated back to 1961. So the government said all the transactions which took place in the last 50 years, we have the ability to tax those transactions. And since then, people have started saying that in India, not only your future, even your past is uncertain. So this became an interesting case study for international investors. Hopefully, the good thing is the new government is more pragmatic, and they have clearly said that we are not going to tax past transactions. We are only going to be futuristic, and all amendments which we'll introduce will be prospective in nature. So broadly, these are the two major tax issues which the deal makers face in India.
Yeah, thank you, Nishchal. And two quick questions, one for Ankit and second for Simon. But let me start with Ankit about shareholder activism in India. It's a recent buzzword in India, and how is it affecting deals in India? That's and of course, second question to Simon, following that, is how is the board reacting, either the governance or other kind of, all these regulatory risks? So if you could just deal with these questions in next 5 minutes or so, that would be very helpful.
So very quickly, the only kind of activism that you heard of a decade back was judicial activism, even a couple of years back. But now there's a new sort of trend, on shareholder activism. Just to step back, why shareholder activism was never sort of active in the Indian context was because of two reasons. One was essentially you have something very peculiar to India which is not so peculiar to Western economies such as the US or the UK, which is a concentrated shareholding model. So, you will commonly hear the term promoters. So a lot of Indian companies, a decade back, it was around 80% of the Indian companies were largely held by promoters who held almost 75-80% of the company. And then there have been changes which has now sort of allowed more institutional participation. So one was that there was no incentive for the minority shareholders to really pursue an activist stance against the majority shareholders who were holding such a large stake in the company. And secondly, there were institutional weaknesses. One was obviously that you don't have effective court mechanisms to sort of resolve some of these issues. Now, what has happened is that, and India has sort of caught on to the global phenomenon. So post 2008, you're seeing more shareholder activism. There's more sort of shareholder engagement. The laws are being oriented towards more and more activism, and India is no stranger to that. So that's one thing that's happened. You have a new Companies Act, you have a new listing regulation which sort of gives more power to the minority shareholders. A second big change that's happened over the last decade or so is that this concentrated promoter shareholding has sort of come down drastically, and you have quite a few Indian companies today which in fact have no promoters at all, and you also have quite a largely the average promoter holding in most of the companies is around 40-45%. So there is a large incentive for some of these shareholders to pursue activist mechanisms. Now, the other thing is the institutional support. Now, as far as the court mechanisms are concerned, there are new tribunals that are being set up which should facilitate some of these, which should provide a resolution for some of these shareholder activists. But at the same time, there are a lot of proxy advisory firms which have come up, which is now giving guidance to these minority shareholders. Now, what you should be careful of as a sort of foreign investor or a foreign acquirer coming into India, as far as shareholder activism is concerned, one is while doing the deal, as you know, it was explained during the first panel that, you know, in mergers and acquisition you could do three kinds. One is asset acquisition, one is a plain sort of merger, and the third is stock acquisition. In all of this, in some form or manner, in fact in merger and asset acquisition, you will always need to go back to the shareholders, and therefore you will need to understand whether you will have enough votes to pass the resolution for a particular transaction. So that's something that you should be careful of while doing the deal. The second aspect which you should, which is very imminent in India, is once you have done the deal, how is it going to affect post-integration? You know, how is activism going to affect post-integration is something that you should be careful of. For example, if you are a pharma company who's buying another company and you would want to enter into a license arrangement with that new target, you need to be careful whether how the other minority shareholders are likely to view such a transaction, and you know whether you'll be able to integrate you know your business or your intention to make the acquisition given all these dynamics at play. So you got to factor in both while making the acquisition, how it's going to affect you, and also post acquisition, you know, you will have to see whether you'll be able to fully integrate, because any sort of value leakage, so to speak, is going to need to withstand shareholder scrutiny in India. And you know, those are the quick thoughts on shareholder activism as it stands in India today.
Yes, so just to continue from where Ankit left, I think we, in terms of shareholder activism as well as the role of the board, we're following closely from a US style of, you know, of detail and duty. In terms of, the board was often seen as a paper sort of a paper board where the promoters, where the controlling shareholders had the say in most matters, including in management. The other shareholders were not even, you know, were not really counted, and no one really bothered to vote. But things are changing drastically now. You know, there are two or three things that have sort of changed Indian shareholder views. One is the media. In India, the media has played a very important role in how you know, corporate India is viewed, the actions of corporate India, and the media. You know, actually following a lot from the US, the media today, you know, threadbare discusses deals, discusses, you know, the consequences of a decision made by a company. So media risk is something that you know, that directors think about as well when having or recommending something to the shareholders. The second bit is the codification of duties of the board in our new Companies Act. Taking in from Satyam, I think there have been mixed reactions to what happened in Satyam. Of course, executive directors, etc., needed to be you know, pulled up. The second bit is how involved were the directors really in the entire management. And the third, a more critical one, is that, you know, if you are today a non-executive or an independent director that can have a limited role, you know, what exactly is your role, what exactly is your liability, and third is, you know, how do you sort of what do you need to do to sort of safeguard safeguard your liability. So the Companies Act, the new Companies Act, has tried to address that by codifying duties. It's extremely verbose and generic. So you know, it is basically common law codified with sort of penalties attributed to it, but it does give a safeguard to certain directors. It says today that if if you've done certain activities, including looking at board minutes and looking at board agendas and you know, and voting on a certain matter and asking the right questions, then there are certain exceptions to be made to how directors viewed. So a lot of liability is cast on directors, and a lot of liability is cast on how decision making is made, what questions are actually asked. And third, you know, to sort of aid the promoters, to aid the directors, you have shareholders today that are very vigilant. We have a lot of proxy advisors. That's a new sort of phenomenon. We didn't have proxy advisors before. We have proxy advisors coming up. In fact, it looks like the business of the proxy advisor is quite lucrative, because we've seen an investment by, you know, a bank having buying into 10% of a large proxy firm in the recent past. So one would question how independent that is going to be, but nonetheless, proxy firms are playing a very important role. And like I said, vigilance vigilant shareholders. Just yesterday or day before, our new Companies Act now requires that every vote for a listed company, the voting is not just physical meetings, it also has to be through electronic votings, so that the penetration and the ability of shareholders to vote is actually given a paid, you pay attention to that, and the shareholder is actually given a meaningful right to vote as opposed to just a paper right to vote. Now SBI, which is State Bank of India, is a listed company governed by a separate act, did not in one of its notices include this concept of e-voting, which is supposed to be mandatory to all shareholders. Along with the media, shareholders themselves have actually created a huge hue and cry as to how SBI has actually sent out these resolutions without having the e-voting concept. So I think the role of the board is also being looked at by shareholders. Shareholders want to play an important role, and I think companies as well as the regulators are paying attention to that. So even if you are invested in a company with a minority shareholder, as a minority shareholder, your voice with the law and with the regulators, with the media, will be heard, and I think that's going to change how decision-making changes in India.
Yeah. So thank you, Simon. I think it has been wonderful, the panel. First of all, let's give a big round of applause. Okay. But I'm not going to deprive you of your questions, but I just want to do one formality, and I want to have my friend Anil Bhandari come here. Just for your information, I never wanted to set up a law firm. And in 1984, 85, he pushed me to set up a law firm because I was a litigator and barrister and, enjoying my solo life and stuff like that. So he said, Nishith, why don't you set up a law firm? So I said, why should I set up one more law firm on the street? There are so many of them. And then ideas came up to do research base and stuff like that. I won't go into the boring details. But he really pushed me, so I want to acknowledge his presence as well. Anil, why don't you come here today? Thanks to your suggestion, we have completed 25 years. I told all of them in the beginning, 15 years of Silicon Valley office, 10 years of Singapore, 4 years of Munich, a new office in New York, where you originally made a suggestion. Consecutively for 2 years, we got the Most Innovative Law Firm Award from Financial Times last year and this year, both in India as well as in Asia. And again, this year, this session was on M&A and deal making, and the merger market. Again, the Financial Times outfit ranked us as the fastest growing M&A law firm in India, and we grew almost 219% last year in that particular space. So thanks to you all. So I just want to acknowledge his incubation of NDA, and I think I would like you to say a few words. And then of course cocktail is there forever, no problem. So please be patient a little bit, and let's give a big hand. But Anil, over to you.
Well, Nishith, thank you very much. It's an honor to be a friend of yours and a close friend of yours for over 3 decades now. But so significantly that this whole session is on deal making, and like Shankar has had success in deal making, my best deal was to really back you, back Nishith. NDA, start off right from the beginning where you were a one-man show, and it's been really privilege and exciting to see how you have grown successfully. You didn't need my help. Really, by the way, I mean, I just happened to be there at the right time because you've done it all yourself, and you've done an amazing job, created a global firm, a very innovative firm with great people who are working with you. I don't say that for you because you've never had anybody work for you. They're all working with you. And again, the last thing is the creation of this NDA research center that you're creating in India is probably going to be one of the most landmark institutions in India. And again, the credit is going to go to you. And again, I wish you the best, and I think you've done an amazing job. Thank you, Nishith, for being a friend.
Yes, thank you. Wait for a minute. May I have, Anil, wait for a minute, I think. I can't reward you so much, but, and Shankar, can I present to you a small token of, of friendship? Yeah?
Thank you very much.
Yes, very nice. Thanks a lot,
Thank you.
Wonderful.
Thank you.
And to Shankar, Thank you so much. Okay. So I think now cocktail is all yours. But before that, we are still open to questions because I do not want to hold up people unnecessarily. But we would be delighted to take questions. We are still here. We will deprive ourselves of some alcohol, but we'll respond to your questions.
Just one
So,
question.
yeah, please go ahead. No problem.
Actually, I wanted to know your views about the observance and breaches and the enforceability of NDAs and NCNDAs as it relates to companies and persons in India. It's been a major concern for people who make deals from out of here. It's very easily enforceable and observed here. I don't know how much it is in India. Would like to hear her comments on that.
NDAs, non-disclosure agreement. Not,
Exactly. Note,
Okay.
Mr. Joy.
Maybe I will take this question.
Thank you.
I think there are two aspects. First, on enforceability in India, it is very, very easy to get interim injunctions, sometimes even ad interim injunctions or injunctions in India, even though it takes time to get into final resolution. When it comes to NDA or non-disclosure agreement, the biggest benefit you are seeking for is how do I stop my confidential information being out in the market. And that is where India has done a fantastic job of protection. And I have seen in my experience, sometimes within 24 hours, you can get an ad interim injunction, which is without even other party knowing about it, get an injunction where he cannot or that other party cannot go and disclose. So that is where I think from enforcement perspective is very, very fast and very, very easy. Now when it comes to final disposal, it takes little time because Indian courts have a lot of backlog and sometimes it takes years and years. So what we have seen people, the strategy which people do is that when they sign an NDA, you will always have an arbitration clause. Arbitration is very fast compared to the litigation. If you are doing an NDA between a non-Indian company and an Indian company, then you can even choose international arbitration. It is not uncommon to go and, even the governing law can be India or any other law, to go and seek arbitration in SIAC in Singapore. That can happen within few months. And now, earlier also it was possible, but now it is possible where you can have an arbitration in Singapore, but you will still have right to approach Indian court to seek interim injunction. So that both options you can have. So you can take Indian courts for purpose of enforcement to get interim injunctions. Meantime, go and seek the final resolution in Singapore so that the whole case can get resolved in less than a year's time. So NDA enforcement has now become very, very.
In fact, Singapore Arbitration Center has been very innovative as well, and including emergency arbitration and other provisions have been introduced. So it is largest number of cases from outside Singapore are coming from India. So it has become very popular, and sometime we'll have a discussion with them as well. Yeah, Ken?
Thank you. Great afternoon. My name is Ken Silverman. I'm head of North America for Sonomus for Consulting, and we bring corporations and universities into India, set them up in business, and so on. I'm not a lawyer or an accountant, so this is a layperson's question and probably relates a little more to the last panel. I had lunch recently with a friend who runs a very large family office. Typically what they do in the U.S. is spend some tens of millions of dollars to buy equity in publicly traded American companies. I said to him, I sold him on all the attributes of India and said, why don't you do it in India as well? And his answer, and here's my question, his answer was that even for an American firm to invest in India, in a publicly traded stock, is very, very complicated. He said you virtually have to be licensed in order to make an investment, separate and apart from the issue of taking money out of India once, in theory, you've made a profit. So in lay terms, how difficult is it for American investors to invest in publicly traded Indian stocks?
Yeah.
Sure.
Nishith.
Yeah. So I think your friend needs to go to the right law firm. It's a very straightforward process to invest in public equity. You just need a foreign portfolio investor license, which you can get in 3 weeks' time. Once you get that license, you can freely invest into India in the public markets. So it's a
Taking
very
money out of
straightforward
country is not a
process.
problem.
There is
Sorry.
absolutely no issue.
And
I think the only criteria is that you can't invest more than 10% through that route, but
Yeah.
other than that, there's no issue.
10% of the value of the company you're
Yeah,
investing in?
you can't acquire more than 10% of the, yeah, it's now 9.99% of the total paid up capital of the portfolio company. But other than that, to get license and all these things are very simple now. In fact, now the securities regulator SEBI has delegated this authority to issue these licenses to designated depository participants. So now there are 15 to 16, you can call them quasi-regulators, which are the banks, and they have the authority to issue these licenses. So they do it very fast, I mean.
And from what you said on the earlier panel, in terms of taking profits or money out of India, you are wiser to do it as a loan than as an investment? Did I?
No, so if the client is investing in public equity, then the exit will be on the stock market.
Right.
So there are no issues. The issue is when the money is sitting in the Indian company and you need to repatriate the money out of India. Here what we are talking about is a secondary exit. So their debt, equity, doesn't matter. You can, the shares of the company are traded, there is liquidity available in the market. You can just transfer the shares on the market.
And just point is that if you sell on a stock exchange in India, there is no tax in India. So that's why you don't need to do any planning in it. It's simple.
There is no tax on publicly listed stock if you sell.
Yeah.
On the market in India, long-term capital gains, there is no tax
Provided you've
principle.
held it for 1 year.
In fact,
They
this is the investing in public markets is the simplest way to invest in India. Rest of the other things are complicated.
And repatriation has not been a problem at all. So that's the easier part. Any other question, any other comment? Yes, please. Please tell your name and
Hi, I'm
organization.
Gautam Shetty from Congruence Medical Solutions. And this scenario should play out in case of PIO and OCIs. Can you talk a little bit more about related party transactions? So if you have a promoter that's in two different countries related, and then maybe a divestiture, or if one entity is acquired by the other or something. So related party transactions, how would that play out?
Sure. So, I mean,
One is under the corporate law, other is in the tax law, and under some other laws as well. So this is under the corporate law. She will tell you a little bit more on that.
Okay, thank you.
so I think related party transactions have, gotten a lot of heat from shareholders as well as the public. Because it was looked at as a way to sort of put, take money from one pocket and put it into the other. And when you take money from one pocket, it's, it's not in favor of the minority shareholders whose pockets you're taking it from. So in India today, you have, you don't necessarily have the controlling shareholders, the promoters, putting all their eggs into one pocket. It's divided into various companies, which is why, related party transactions have now been cast with a different lens, under different lens completely. For related party transactions, in certain related party transactions, including selling, leasing of assets, which are not in the ordinary course of business, you require shareholder approval, one, and in that shareholder approval, the related party, that means the promoter, assuming it's the promoter, cannot really vote. So you need the majority of the minority to actually vote in favor of that transaction for it to go ahead. Second, there are a lot of concerns on, not just from a tax perspective, but also in terms of pricing, in terms of, how arm's length the transaction really is. And it can't really be less than arm's length because, again, you need to sort of sell it to the shareholders. If you are investing, if you have a listed company, there are, far more stringent corporate governance norms that need to be adhered to. Including, directors cannot really vote on that matter. Interested directors, both from a public, unlisted as well as listed company, the interested directors cannot really vote on the matter. And you require certain, additional compliances if you are doing a listed transaction. It gets into more scrutiny. But this is why, sort of, to ensure preservation of wealth in the company itself and to avoid, and I think the most talked about case in the recent past is the Maruti Suzuki situation, where Maruti Suzuki is, one of the most successful sort of joint ventures, the Japanese joint venture, where the car manufacturer in fact, it sells sort of more cars in India than it does in Japan, and it's the export hub for the rest of the world. Now, what was happening there was, Suzuki wanted to have its own setup in India, devoid of Maruti, which is a listed company, Maruti Suzuki, it's joint venture, and what the company was going to do is lease a large portion of land that it had, a long-term lease, to that promoter entity, and also I think the expansion plans for Suzuki were going to be held in that new company and not the listed Maruti Suzuki. There was a lot of sort of hue and cry as to the entire matter, even though technically speaking, because it was a very small plan, this was the time when the Companies Act 2013 was not in force. There was so much concern, by shareholders as to how this deal was actually happening, whether it was going to be diversion of diversion of business into a completely new entity which the minority shareholders didn't have access to, and it came about a lot of it came through a lot of public scanner. It's still sort of terms are still being negotiated, even though 2 years have actually passed, to ensure that it becomes favorable and the minority shareholders don't really lose out. So related party transactions are common in India, but given the new law and given the overall sort of view of the public on this, it's being viewed with a lot of scrutiny.
So I think that's on the corporate law. On tax side, the transfer pricing regulations, drive the relationship or the transaction between two people, one of whom should be non-resident. Domestic transfer pricing is still not there like in the US at this point in time, but post 2017, when we'll have general anti-avoidance provisions, possibly those will also be covered. So just for information, that's the thing. Any other question? Any other? Yeah, please.
Hi, I'm Pankaj from 500 Startups. I want to shift gears a little bit back to what we were talking about in the first half, which is the whole Startup India initiative that the Prime Minister announced a couple of weeks ago. There's been a lot of talk about how it benefits startups and perhaps even some domestic investors, but there hasn't been a lot written about how it benefits foreign venture firms like us and what we can do that we couldn't do prior to this being announced. So if there's any information you have about that, that would be great.
I think as far as foreign venture capitalists are concerned, now there is a regime also for the domestic venture capital fund in which foreign investors and foreign venture capital funds can invest. And there is already a kind of mania on the startup at this point in time, as you know. A lot of things are being done, and depending on how your foreign venture capital fund is structured, there are certain tax benefits. But the new provisions that are coming up, I think Weber can tell you a little more. If you can just
quickly, you're right. Currently, in fact, we had given, as I was saying, I was part of NASSCOM as well as TAI committee, which we had made presentation to the government of what they should announce, and we had given more than 36 recommendations which they should, and they have in principle accepted it, but they have only announced 3 or 4 which directly to startup. They have not announced anything with respect to the venture capital or foreign venture capital investor investing in Indian startups as of today. We believe that will happen over a period of time. What I understand and what was told publicly also is that some of them may come, especially with respect to capital gain, may come in the budget discussion also. So that's something we need to wait for.
There would be some tax benefits given to the investors in the startup, long-term benefit. Can we discuss this outside,
Sure.
if you do not mind?
Yeah, absolutely.
Because I think some people are waiting.
Getting thirsty.
I know a lot of other people are also waiting for, cocktails. It would be unfair for me to hold them up, but thank you so much, and please do not forget to take your books when you go out, and somebody will be always happy to help you. You can leave them here and take it whatever way you want. And thank you so much, and thanks to you all. So for that.